Hi friends, I'm here today to talk to you about the business records exception to the rule against hearsay. And before we get into the exception, I'd like to talk about the rule. The rule against hearsay it makes hearsay inadmissible in a court of law except for certain exceptions. And the rule against hearsay is that hearsay is an out-of-court statement offered to prove the truth of the matter asserted. Okay? Now, you have to listen to every part of that rule to really understand it. First of all, it's an out-of-court statement. It's not given under oath. And it's given to prove the truth of the matter that's asserted. In other words, let's suppose I hear somebody running around saying the sky is falling, the sky is falling. Okay, that statement wouldn't be admissible to prove that the sky is really falling. It would be admissible, though, to show that the person is crazy or that they were operating under some sort of delusion or incapacity. So if I'm offering it to prove that the person had some kind of mental incapacity, it would be admissible because the statement is not being offered to prove the truth of the matter asserted in the statement. It is offered to prove something else about the person making the statement or whatever. Clear as mud? So it is an out-of-court statement offered to prove the truth of the matter asserted. So if someone runs around saying the sky is falling, I can't offer that statement as evidence that the sky is actually falling. I can offer it to prove the mental state of the person making the statement, though. So that's the rule against hearsay, that kind of thing, a statement not made under oath, is inadmissible. Now, there are certain exceptions to this rule that are considered to be more reliable than an average hearsay statement and therefore admissible. One of those is the business records exception. That is a record of an act, event, condition, opinion, or diagnosis if the record was made at or near the time of the thing you're trying to prove, or from information transmitted by someone with knowledge. So it has to be contemporaneous with whatever is being proven, roughly, and the person making the statement has to have transmitted it with knowledge. Secondly, it has to be a record kept in the ordinary course of a regularly conducted activity of a business or organization. Could be a charity, could be a church, could be any organization, whether or not that organization is for profit. But it has to be a record kept in the ordinary course of business, and making the record is a regular part of the activity of that organization. In other words, a special report prepared in anticipation of litigation probably doesn't work. However, accounting records of the organization may well be admissible under the business records exception. Invoices probably are. That sort of thing. All of these conditions have to be, of the record and the keeping of the record, have to be testified to, preferably by the custodian of the record or another qualified witness that knows about the keeping of this record. And they have to certify it, and I'm not going to go into the details of how they would do that, but that's just know that that's part of it. Is this important? Well, in early 2017, I went to trial about some damage to a home. And the pivotal piece of evidence that the whole thing ended up turning on was a letter written on a word processor, and it was unsigned, and it stated certain opinions of an expert about a particular home. And there was no testimony from the custodian of the record. There was no indication that it was kept in the ordinary course of business. So I objected on grounds that it was hearsay. My opposing counsel asked for a recess in the trial. He went out, he subpoenaed the business owner that had purportedly created this document, brought him in to testify. He tries to get him to testify, is this a record that's kept in the ordinary course of business? And the business owner says, I don't know, I've never seen it. I don't remember ever saying this or writing it. And if you think about it, this is why the rule exists. Because you don't want people coming into court saying, hey, here's a piece of paper written by so-and-so. No, you're supposed to bring so-and-so in to the proceeding and have them testify and have them subjected to cross-examination. And it's a big part of our system of due process of law, and that's one reason why hearsay records are not allowed into court. This particular record did not satisfy the business records exception, and it was kept out. And it was pivotal because it was purporting to be the opinion of this person who had done work on the house and examined it and knew about the damage, and he testified that he didn't remember the condition of the house, that this letter did not refresh his memory. And so yeah, it's very important. What do you as a business owner then do? First of all, I suggest think about the kind of evidence you would need in a dispute with a customer, a vendor, an employee, or anyone else you might do business with. What kind of evidence might be necessary to cover yourself in a dispute? Secondly, keep records of all of that kind of thing in the ordinary course of your business. Invoices, receipts, all of that kind of stuff. Third one, I'm going to delve slightly into another exception to the rule against hearsay, and that is the self-authenticating documents rule. A self-authenticating document has some of the indicia of reliability. Even though it may be a hearsay statement, it is on company letterhead, or there's a company seal or logo on it. That kind of thing. And it is considered to be a little bit more reliable. I suggest that any important record that you have that you want to make sure can be admitted into evidence if something ever goes to trial, such as invoices and things like that, always put your company logo on those kinds of documents in the ordinary course of your business. Don't wait until litigation is anticipated and then copy it onto letterhead or something like that. I've actually seen people get in trouble for doing that. In the ordinary course of your business, put it on letterhead or put your logo on it or something like that. All right, so just to summarize, hearsay is an out-of-court statement offered to prove the truth of the matter asserted. So sworn testimony, even in a declaration or an affidavit, is not hearsay. But hearsay is an out-of-court, unsworn statement offered to prove the truth of the matter asserted. An exception exists for business records. That's a record that's made contemporaneous with the events you're trying to prove. It is kept in the ordinary course of business, and making the record itself is something that occurs in the ordinary course of business. And then all of these conditions are shown by the testimony of the person keeping custody of the records or some other qualified witness to that, that the record is kept in compliance with certain conditions. So, important rule, and I suggest, as I said, think about the evidence you would need in a dispute with anyone you do business with, internally or externally. Keep records of such things, and then keep them on self-authenticating documents, things with your logo or letterhead on them. All right? If you have any questions about this or how it pertains in your situation, don't just rely on this video. Feel free to private message me or call me. And I hope this has been valuable for you, and we'll talk again soon.